So what are family provision claims?
Family provision claims is sort of a general term that stems from a piece of legislation known as the Inheritance Provision for Family Independence Act. It's dated back in 1975, and it allows certain categories of applicants to bring a claim against the deceased person's estate if for example, they've been left out of a person's will or may not benefit under the intestacy rules, which dictate how a person's estate is to be distributed if they die without a valid will.
Can you tell me who can bring a claim?
There's various categories of applicants that can bring a claim. So the first one would be a spouse a surviving spouse. It can be a previous spouse from a prior marriage if they haven't remarried. Also, cohabitants can bring a claim. There's provision that they need to have resided with the deceased as husband and wife for 2 years preceding the deceased death. And there's a category for children. That includes adult children, that's not just minor children. And then people who are treated as children of the deceased, so for example, stepchildren. And then finally, anyone that was maintained by the deceased person immediately before their death. So for example, cohabitants who may not fall into the 2-year proviso, living as husband and wife, could potentially fall into that other category.
Can you give some examples of when a claim may be brought?
Yes, so there may be a second or third marriage that the deceased entered into, and under their will they may have left the entire estate to their blood children and completely cut out the new spouse. So children from a prior marriage, they may have received everything, so the new spouse who's been left in the matrimonial home hasn't received anything. Maybe an example. You have similar matters with cohabitants and partners who wouldn't benefit under the intestacy rules, for example, and the deceased may not have updated their will. And then finally, you may have a child who, under a will made by the deceased many years ago, their financial position has changed drastically. Their business, for example, could have gone out of their business and been affected financially, which may mean that resulting on the deceased death, they've actually received nothing when in fact they do require some provision.
What are the stages to a claim?
So there's two stages. The first stage is, does the deceased estate make reasonable provision for the applicant? There's two actual categories that a person may fall into. For all applicants other than a spouse, it's what is reasonable financial provision is defined as being what is reasonable financial provision for their maintenance. And maintenance isn't defined, but it's said to be what is required for their daily living. So not necessarily luxuries, but what they need on a day-to-day basis, what they may have been accustomed to by being maintained by the deceased. Whereas spouse, it's what's reasonable financial provision in all the circumstances, so there's no limitation on maintenance. It's said that divorce principles tend to similarly apply when there's claims by spouses and what the spouse may have reasonably received as a result of a divorce from the deceased. The second stage is then, if they can pass that first part of the test, what is reasonable financial provision from the estate, and what should the award be?
What does the court take into account at each stage?
So there's various factors, it's under section 3 of the legislation, that the court would take into account. So there's general factors and then there's specific factors relative to the category of applicant. So the general factors may be the financial needs and resources of the applicant themselves and what their future needs may be, the size and nature of the deceased estate, and also the financial needs and resources of the other beneficiaries in the estate. The more specific ones, for example, with a spouse, it will be the age of the applicant and the length of the marriage, and also what contributions they made to the marriage. There'll be specific ones relative to the category, for example.
Are there any other considerations to be aware of?
The main other one probably is time limits. There's a deadline to issue proceedings if you're going to bring a claim under the Act. So that's 6 months from the date that a grant of representation is issued. So that's either the grant of probate or grant of letters of administration, the two main types of grant. From the date that that's issued, clock starts ticking of 6 months to issue proceedings under a claim. So it's important to be quite quick in terms of taking advice.
How do you bring a claim under the Act?
It's quite a broad range of factors to be considered under the Act. So it's quite important to seek some professional advice first off, just to fully assess the merits of any claim and go through relative to those general guidelines and the specific guidelines as to whether there would be a case. But it's important to get professional advice first, and then steps can be taken after that if there is good merits to the case.